rejected. You ask the courtmaster later why it has been rejected. You ask the courtmaster later on why it has been rejected.
From supplementary list for final disposal, item 4, WPL 6656 or 2006 along with item 5.
First appeal. First appeal. मैडम रश्मि कुमार और मिस्टर प्रकाश कुमार दोनों को बिल बांधिएगा, ठीक है? फर्स्ट अपील 181 of 2007. This appeal has been filed. Clearance में लिखिएगा. Appellant is for appellant Mr. Prabhash Kumar and for respondent Ms. Rashmi Kumar. This appeal has been filed against the judgment and decree against the judgment dated 18/7/2007 and decree signed on 28/7/2007 passed by learned subject Jamshedpur in money suit number 13 of 1999. Whereby the learned court has refused to grant the relief of compensation claimed by the plaintiffs amounting to rupees 50 lakhs in favor of plaintiff number 1 and 2. Madam, I am reading the dictation of first appeal, but for tomorrow's 33 C2 matter, I have seen numerous judgments of the Honorable Supreme Court which says that if there is a direction for payment of packages, it has to be quantified under 33 C2. But at the same time, you can see the Industrial Disputes Act, which says that bonus is excluded. So bonus I will allow, that cannot be granted, subject to what Mr. Prabhash has to say. I got that judgment also. Which is an judgment or Industrial Disputes Act.
Bonus regarding bonus.
Please don't. I'm just dictating this first appeal, and then let Mr. Prabhash Kumar come. He comes slightly late to the. Let him come. I will continue the dictation.
बोनस तुमको
अरे भाई आप समझ नहीं रहे, अभी फर्स्ट अपील खत्म होने दो. As for the case of the plaintiffs, they were it is important to note that the plaintiffs have already expired and they are being represented by the legal representatives before this court. As per the case of the plaintiffs, the plaintiff number 1 as well as plaintiff number 2 were ex-employee of the defendant, and they were terminated by the defendant when they were remanded to judicial custody. However, they were ultimately acquitted by the court. Initially, a case was filed before the learned presiding officer, Labour Court Jamshedpur, seeking relief of reinstatement and consequential benefits and consequential relief. And challenging the order of termination. But such relief was denied to the ex-employees involved in the present case. And ultimately, the relief was granted to them in CWJC number 140 of 1978 (R) by the High Court, wherein they were reinstated with packages, including other reliefs. Against the said judgment of the High Court, the special leave petition being 7145-46 of 1983 was also dismissed, and the plaintiff number 1 and husband of plaintiff number 2 were to be reinstated. It was the further case of the plaintiff that plaintiff number 1 and husband of plaintiff number 2 joined the service, and the plaintiff number 1 retired after 2 years, and so far as husband of plaintiff number 2 is concerned, he died within 2 days from rejoining his service due to weak health. It was alleged that the plaintiff number 1 and the husband of plaintiff number 2 both suffered continuously for 26 years and 6 months due to mental agony and torture, and also suffered defamation in the society. They suffered starvation, lack of education and medical facilities, and also defamatory action made by the officials of the defendant company, who were under legal obligation to provide them medical and education facilities by way of reimbursement, but no such facility was provided. Consequent upon the action of the defendant company, the plaintiffs suffered irreparable loss, and career of their children was ruined at the instance of the defendant company. And due to non-availability of medical facilities by the defendant company, the deceased husband could not take proper medical treatment and died within 2 days of rejoining his service. it was their specific case that on account of action of the defendant, the plaintiff, by which the plaintiff number 1 and the husband of plaintiff number 2 were terminated from service. They suffered huge losses, and they were required to be compensated by giving rupees 50 lakhs. A legal notice was sent, but no response was received, and consequently the case was filed by way of money suit number 13 of 1999. On the other hand, as per the written statement filed by the defendant, the suit was not maintainable and there was no cause of action. It was also alleged that the suit was barred by the provisions of Specific Relief Act, waiver estoppel accusations, and also barred under the provisions of Bihar State Weaker Section Legal Aid Act 1983. As by virtue of Legal Aid Act, the plaintiff number 1 got exemption from court fees, suppressing his true financial status. It was for the case of the defendant that the plaintiff number 2 was not financially weak, and she was required to pay the ad valorem court fees, as no certificate for exemption was granted to plaintiff number 2. It was the details of various payments made to the plaintiff number 1 and 2 were also mentioned in the plaint. So far, a plea was also taken that the other legal years of Mrinal Das Gupta, the ex-employee, were not made party in the proceedings. So far as the merit of the case is concerned, the defendant specifically took a plea that the termination was not wrong, and the plaintiffs did not suffer any loss and injury because It was also pointed out that one MJ case number 16 of 98 was filed before the presiding officer Labour Court, claiming the relief arising out of order passed by the High Court, and therefore the claim in the suit was not maintainable. It was also averred that the medical facilities were available to the employees and their family members who were on the roll of the company, and there was no such provision for payment of any medical expenses to an employee who was not on roll. Similarly, educational allowances was also payable to employee. On his declaration that none of his children are studying in company aided school but are studying in other school, and no such declaration was made. And the claim of educational allowances was also denied. It was further averred that claim of medical and educational benefits was made in the petition filed under section 33C2 of Industrial Disputes Act in MJ before the Labour Court in MJ case number 168 of 1998, and therefore no such relief could be granted by the learned court in the money suit. It was also asserted that the service of plaintiff number 1 and husband of plaintiff number 2 were terminated due to long absence from duty, and defendant did not defame them and did not debar them with any wages for which they were legally entitled. And it was asserted that the entire claim was imaginary and hypothetical, whimsical, and baseless. The learned court framed the following issues for consideration. The plaintiff led four witnesses and filed documentary evidence in the shape of, namely, carbon copy of legal notice dated 8 to 99 Exhibit 1 and postal receipt dated 10 to 99 Exhibit 2. The defendant led only one oral evidence examined as DW1 and also filed certified copy of the order dated 18/1/2006 passed in NJ case number 16 of 1998, which was marked as Exhibit A. The learned court first decided issue number 5, which was decided against the plaintiffs. So far as issue number 6 and 7 are concerned, the learned court held that plaintiff number 1 and the husband of plaintiff number 2 did not sustain any mental torture for which they could be compensated by awarding damages, and also held that the cause of death of husband of plaintiff number 2 was not due to negligence of the defendant company in providing medical facilities during the period of termination, and for that no damages was required to be awarded, and both the issues were decided against the plaintiffs. So far as issue number 3 is concerned, the same was not pressed by the defendant and was decided in favor of the plaintiff. With regard to issue number 6, the learned court decided it in favor of the plaintiff. So far as issue number 1 and 2 are concerned, the learned court held that issue number 5, 6 and 7 having been decided against the plaintiff, and it was found that the plaintiffs had not suffered any injury by act of the management of the defendant company for which they were required to be compensated by awarding damages, and therefore the plaintiffs failed to establish that the defendant company had violated any terms and conditions of service by making termination of plaintiff number 1 and husband of plaintiff number 2 with any intention to lower down the reputation of the plaintiff number 1 and the husband of plaintiff number 2. It was also observed that the plaintiffs had not adduced any evidence on the basis of which their claim of compensation could be computed reasonably, and had not proved that they suffered any civil wrong. And ultimately held that the suit for damages as claimed was not maintainable and the plaintiff had no cause of action for the suit. The issue number 1 and 2 were decided against the plaintiffs. As a result of the aforesaid findings with regard to different issues, the suit was ultimately dismissed. The learned counsel for the petitioner, for the plaintiff's appellant, has assailed the judgment by submitting that the plaintiff number 1 and the husband of plaintiff number 2 were taken into judicial custody on account of which they were terminated by the defendant, but ultimately they were acquitted by the criminal court. In such circumstances, the action of the defendant was the action of the defendant in termination of the ex-employees was without any basis, which resulted in the fact that they remained out of service for 26 years and 6 months and suffered mental agony, torture, defamation, and their family suffered on account of education and medical facilities. He has also submitted that the very fact that the husband of defendant number 2 expired within a period of 2 days from the date of joining was enough to indicate that he suffered on account of lack of medical facilities extended to him from the side of the defendant company, and therefore and in view of the aforesaid facts and circumstances, the plaintiffs were entitled for the compensation as claimed by them, that is to the extent of rupees 50 lakhs. The learned counsel appearing on behalf of the defendant, respondent, has opposed the prayer and has submitted that even the judgment of acquittal was not placed before the court. She has also submitted that no case of malicious prosecution was made out, and merely because the ex-employees were acquitted in the criminal case, they were not entitled for any damages. She has also submitted that the matter regarding termination of their service, she has also submitted that the ex-employees were terminated way back in the year 1970, and after being acquitted and being released from judicial custody, they filed case before the presiding officer, Labour Court Jamshedpur, challenging their order of termination, which was initially refused by the Labour Court, and consequently there was no occasion for the respondent to take them back in service. However, the relief was granted to them by the High Court in CWJC number 1014 in the writ petition filed, where they were directed to be reinstated with consequential relief with back wages, and the matter was ultimately decided by the Honorable Supreme Court, and immediately thereafter they were taken in service. She has submitted that no case for damages was made out, and they were already pursuing their relief under section 33C2 of the Industrial Disputes Act, whose final judgment was exhibited before the court also, before the learned court. Considering the submissions made, the counsel for the appellant has also submitted that the entire issue revolves around issue number 5 issue number 5, which would be the point of determination by this court. He has also submitted that the entire relief is based on determination of issue number 5. Consequently, मैं उसके बाद लिखेंगे उनके submissions के बाद. The point for determination by this court is issue number 5. Whether the defendant company had committed a tort of malicious prosecution against the plaintiff number 1 and husband of plaintiff number 2, and whether their reputation in society was lowered down so as to be compensated by awarding damages. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that although the plaintiffs made a plea of malicious prosecution, raised a plea of malicious prosecution, which was primarily based on the fact that they were ultimately acquitted by the criminal court, but even the judgment passed by the criminal court acquitting them was not exhibited by the plaintiffs before the court. This court further finds that the learned court, this court is of the considered view that merely because a person is subjected to criminal case and is ultimately acquitted, the same does not occasion to give any finding of malicious prosecution. The learned court, by deciding the aforesaid issue by issue number 5, has clearly held that the plaintiffs did not produce any documentary evidence in support of their case, and has also held that the basic ingredients for coming to a finding that a finding of a malicious prosecution were not produced or proved. The learned court also held that for want of judgment of the copy or the copy of the FIR, it could not be said that the criminal case was instituted without any reasonable or probable cause. The learned court also discussed the testimony of PW4. The findings of the learned court with respect to issue number 5 is quoted as under. This court has gone through the materials on record and also the findings recorded by the learned court, and is of the considered view that in absence of the FIR and also the judgment of acquittal, there was no occasion for the court to come to a conclusion of malicious prosecution in favor of the plaintiffs. And consequently, the malicious prosecution was not proved at all. In view of the opposite facts and circumstances, this court is of the considered view that so far as issue number 5 is concerned, the learned court has rightly come to a conclusion and decided the same against the plaintiffs. There is no such material and no such argument has been advanced before this court to come to a different finding as what has been recorded by the learned court. Rather, the judgment passed by the learned court is a well-reasoned one. So far as that is all. This is the only point of determination.
Another point is they have taken, since they have filed a petition under section 33C2. So,
We need not worry about it. This all the reliefs are flowing out of issue number 5 only.
but they have observed that since they have filed an application under section 33C2.
That is not, there is no such observation under issue number 5. So far as other issues are concerned, this court finds that the learned court has considered the materials on record.
Page 22, there is the observation to that effect also.
Not while deciding issue number 5.
No.
That is not while deciding issue number 5. उसके बाद yes, so far as issue number 6 and issue number 7 is concerned, this court finds that the plaintiffs had remained out of employment since 1970 and were reinstated and even the judgment passed by presiding officer Labour Court Jamshedpur regarding challenging their order of termination was decided against them, and ultimately the relief was granted only in the writ petition, which attained finality by virtue of judgment passed by the Honorable Supreme Court. There was a direction to by the Honorable Supreme Court. Even the judgment of the Honorable Supreme Court, Honorable High Court, our High Court, and the judgment passed by Labour Court were not exhibited before the court concerned. कोई exhibit नहीं. The only document which was exhibited with regard to the order was the certified copy of order passed in MJ case number 16 of 1998.
Legal notice dated 8 to 99.
Legal notice is nothing.
Nothing.
उसका क्या मतलब? In view of the fact that the plaintiff number 1 and the husband of plaintiff number 2 were not on the rolls of the company, there was no occasion for the company to extend any service benefit or medical facilities to them. Further, no documentary evidence were produced before the court regarding their treatment or their ailment. This court finds that the learned court, after considering the materials, decided the issue as mentioned above. During the course of arguments, no illegality with regard to the findings recorded by the learned court has been pointed out by the learned counsel for the appellant. Consequently, as a cumulative effect of the aforesaid findings, the point of determination having been decided against the appellants and the other issues framed by the learned court having been decided in accordance with law, this court finds no merit in this appeal, which is hereby dismissed. Yes, so far as that idea,
One submission.
आप थोड़ा सा submission करिए, क्योंकि we will not be able to say that it was not maintained.
Ladyship took me a query that regarding the bonus. Only section 8 I would like to refer.
Section?
8 of bonus act. Payment of bonus act.
Bonus is not payable. That I have already indicated. You did not argue it also yesterday. सारा homework तो हम लोग को करना है ना. आपको कोई मतलब ही नहीं है. Bonus is not payable under back wages. That judgment I have got. आप तो नहीं लेके आए. नहीं ना लेकर आए.
Section 8 of.
I am just telling you. Did you bring that judgment yesterday? No. You did not bring that judgment. सारा judgment खोजने का काम तो मेरा ही, आप लोगों का काम थोड़ी. Yes, bonus is payable. You read that. You read the wages. Definition of wages. You read the definition of wages. Bonus is specifically excluded.
Section 8.
Eligibility of bonus, every employee shall be entitled to be paid by his
नहीं वहाँ नहीं.
हाँ.
ID Act. A direct judgment आपके खिलाफ. There is a direct judgment under the IT Act. Bonus नहीं मिल सकता back wages. So bonus you will not get.
Yes.
So far as the rest of the, in fact, the learned court has not even considered the definition of wages under the IT Act, although it was considering the IT Act provisions, right? And so far, I have not come across any judgment of our High Court at least, which clarifies as to what will be the component of back wages. There is absolute confusion on that. So I would like to pronounce on this, such that at least some of the elements which are otherwise not included may not be included at the time of grant of back wages. Right? So you read the definition. Wages, आप भी पढ़िए madam. Bonus नहीं मिलता है, but does not include bonus any contribution paid or payable by the employer to any pension fund. The pension fund में भी आपका contribution is not included in wages. Any gratuity payable on termination of service. This is also not included in the definition of wages under the IT Act. What is included is your LTC. Any travelling concession.
Yes.
That is included. Then, so far as your dearness allowance is concerned, that is included. And further, they have given you one more thing. The increments are concerned, annual increments, which are routine, that is payable. These three things are payable, but computation has not been done. And under the provisions of section 33C2 itself, there is a provision by which, by what method it can be done. You can have a commission, and that computation is required to be done. Because a certificate is to be issued that this much of amount is payable. जैसे land acquisition में quantum होता है, वैसे ही 33C2 में quantum is absolutely necessary to be determined.
In fact, Marcy, the 33C2, when it acts as an executive award which has been.
That's right. Quantification के लिए हमको भेजना पड़ेगा. Quantification के लिए हमको भेजना पड़ेगा, but bonus will be excluded. वो नहीं कर सकते. That should be sufficient.
DA has been paid.
नहीं, जो भी पेमेंट, एक सेकेंड और मैडम, वॉट एवर यू हैव पेड दैट विल बी टेकन केयर ऑफ एट द टाइम ऑफ कंप्यूटेशन. डबल पेमेंट तो नहीं होगा. वॉट एवर दे हैव पेड that will be taken care of at the time of computation. Either they will produce the evidence or they can appoint a commission in terms of 33C2 में, है ना, commission का appointment. For the purpose of computation of money value of a benefit, the Labour Court may, if so thinks fit, appoint a commissioner who shall, after taking such evidence as may be necessary, submit a report to the Labour Court. Either the court can do it himself, and it will be for the employer to produce the evidences. Because now the ex-employee is no more, we don't cast any burden on them.
Legal representatives are there.
हाँ,
Both the
आप कहाँ से एविडेंस लेके आएंगे? जो एविडेंस लाना आपको लेके आना, ठीक है? ये दीजिए. और वो एक और जजमेंट, ये तो उधर से लेके एक और जजमेंट आपको गुरु जी पे भेजे थे ना, यही वाला था. एक नंबर पे था. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioners, that the ex-employees, namely M से क्या हुआ? M दासगुप्ता. M is what? पूरा नाम क्या? नहीं, M दासगुप्ता.
मृणाल दास.
मृणाल.
मृणाल दास.
This court finds that Mrinal, that two workmen are involved in the present case, namely Mrinal Dasgupta, namely Kumar Krishna Murmu.
First is
Kumar Krishna Murmu, hereinafter referred to as the employee number 1, and Mrinal Dasgupta, hereinafter referred to as the employee number 2, were arrested by the police in the month of May 1970, and they were discharged from services of the petitioner with effect from 10/6/1970 and 12/6/1970 respectively.
Under section 47 of the standing order.
Whatever is the month. The learned, their order of termination, their order of discharge was subject matter of consideration in reference case number 1 of 1974. And an award was passed on 13/10/1977, wherein they were not granted any relief. The operative portion of the award is quoted as under. Annexure 9 का है. तो ग्रीन नंबर से जो पेज नंबर किया हुआ है 94. The award was subject matter of challenge before the High Court, and ultimately the matter was decided by the High Court in favor of the aforesaid 2 ex-employees, and they were directed to be reinstated with back wages from the dates their services were terminated, with a further direction that any amount that was paid to them in pursuance of the provision of Standing Order number 47 be adjusted towards the dues before making any further payment. The findings of this court in writ petition being CWJC number 38 of 1978 with 140 of 1978 is quoted as under. Quote per region, para 15. The matter travelled up to the Honorable Supreme Court, and ultimately the special leave petitions were dismissed. Soon thereafter, the aforesaid 2 ex-employees were taken in service. The employee number 2 expired after joining the service, and consequently the ex-employee number 1 and the widow of ex-employee number 2 filed a petition under section 33C2, read with section 29 of Industrial Disputes Act 1947, which was numbered as MJ case number 16 of 1998. And the claims were made under different heads, which are as follows. Para number 10 में मिले आपको, पेज नंबर 38, और ये petition है Annexure 4, पेज 36. Further in para 10 and 11 में, 10 and 11, दोनों को. The petition was opposed by the petitioner inter alia by stating that the amount, the admissible amount was already paid to them. and with respect to each head under which the claim was made, objections were raised. The learned court considered the various objections. They considered the case and the materials produced by the parties. Altogether 4 witnesses were examined on behalf of the applicants, and following exhibits were produced. Page number 59 maybe, para number 7 of the implement. On behalf of the management, only 1 witness was examined, and following documents were exhibited. Para 8. The learned court considered the materials on record and recorded a finding with respect to, and ultimately allowed the petition partly to the and directed the petitioner to pay an amount equivalent to yearly increment with variable dearness allowance within bracket PDA for the period of 27 years after fitment of wages year-wise, semicolon, fixed annual bonus at the rate of 8.33%, semicolon, payment of earned leave equivalent to 182 days, and 6 leave travelling concession allowance. So far as the claim with regard to education allowance, medical allowance, sick leave encashment are concerned, the same was rejected by stating that, by inter alia stating that no evidence were produced to that effect. The learned counsel for the considering the arguments the learned counsel for the petitioner has specifically argued that the petition itself was not maintainable in view of the stand taken by the management and the dispute raised by the management under each head. She has also submitted that otherwise also, so far as the amount relating to annual bonus, direction to fix annual bonus and pay the same is concerned, the bonus could not be included as a part of back wages, and for that purpose she has referred to the definition of wages as defined under the Industrial Disputes Act. She has also submitted that under the provisions of Payment of Bonus Act,
Section 8.
Payment of Wages Act,
Payment of Bonus Act 1965, Section 8.
Section 8, क्या है इसमें? Amendment है ना 67.
Employee should work for 30 days, then he is entitled.
And submits that unless employee works for 30 days, there is no entitlement of this. She has also submitted that the impute order has not arrived at any computation. On the other hand, the learned counsel appearing on behalf of the respondents has opposed the prayer by submitting that the impute order has considered every aspect of the matter, and in terms of the provisions of, in terms of the definition of wages as defined under Industrial Disputes Act,
2
under section 2 within bracket RR, wages includes all allowances including dearness allowance, and also includes travelling concessions. So far as the exclusion of bonus is concerned, he has nothing to say. क्या बोलना है?
Exclusion of once he has been reinstated in service with effect from the date of his termination, then it is deemed that he has worked. He has worked and he is entitled for bonus.
So far as bonus is concerned, he has submitted that the ex-employee having been reinstated in service, it is deemed that he has worked, and therefore he is entitled for bonus. He has also submitted that the objections which were raised by the management was only for the sake of objection, and there was no merit. The petition was maintainable as it was essentially by way of execution of the award, of back wages in favor of the ex-employees. ठीक है ना? यही आपका?
Lordship, under section 33C2, the executive court can interpret the award as per the award passed.
Yes. He has also submitted that executing court can interpret the award while considering the petition under section 33C. In the judgment passed by the The judgment passed by the Honorable Supreme Court, reported in bracket 2005, bracket close 8 SCC 58, State of UP and another versus Brijpal Singh. The provisions of Section 33C2 were under consideration. And it has been held that the Labour Court has no jurisdiction to first decide the workman's entitlement and then proceed to compute the benefit so adjudicated. On the under Section 33C2 of Industrial Disputes Act, and it is only when the entitlement has been earlier adjudicated or recognized by the employer and thereafter for the purpose of implementation or enforcement thereof. Some ambiguity requires interpretation. That the interpretation is treated as incidental to the Labour Code's power under Section 33C2, like that of the executing court's power to interpret the decree for the purposes of execution. This court finds that the entitlement for back wages from the date of termination stood decided in favor of the ex-employees by virtue of the order passed by this court in the writ petition wherein the award passed by the learned Labour Court was under challenge. Consequently, the entitlement of ex-employees to receive back wages from the date of their termination stood crystallized. In such circumstances, this court is of the considered view that the petition filed under Section 33C2 of the Industry Disputes Act was maintainable. So far as the
yesterday I had said that once the award has been passed, then this right under Section 33C2 automatically flows in favor of the ex-employee.
as back as in the year 1964, in the judgment reported in AIR 1964 ST 743, while considering the scope of proceedings under Section 33C2 of Industry Disputes Act, in para 18 it has been held that there can be no doubt that when the Labour Court is given the power to allow an individual workman to execute or implement his existing individual rights, it is virtually exercising execution power in some cases, and it is well settled that it is open to the executive court to interpret the decree for the purposes of execution. It has been held as under. इसको quote करें. ये जो हम लोग का पुराना जजमेंट है इसी में LPA 379 of the Constitution. Having held that the petition under Section 33C2 for claim of back wages in terms of the order passed by this court was maintainable, it is to be examined as to whether the learned court has rightly exercised its power for the relief which has been granted. Although the relief was prayed for under multiple heads, but the learned court has only directed for making payment of amount equivalent to yearly increments with variable dearness allowance for the period of 27 years. Wages मिल गया था ना आपको otherwise. As apparently the wages without increment was already paid.
Wages was calculated on the basis of the last paid round.
And it appears that was already paid. This court is of the considered view that so far as the aforesaid direction is concerned, the discussion is in paragraph 12, which is as under court continued. After going through the aforesaid findings in paragraph 12, this court is of the view that the same is a well-reasoned finding based on materials on record, and there could be no dispute with regard to entitlement of the annual increments. The Dearness allowance is specifically included in the definition of wages as defined under Industrial Disputes Act. Consequently, the said direction does not call for any interference. So far as the further amount which has been paid, but further direction has been made to fix the annual bonus at the rate of 8.33%. This court finds that the discussion in that connection is at para 13, which is quoted as under. This court finds that the learned court, by considering the aforesaid grant of aforesaid relief, has not at all considered the definition of wages as defined under the Industrial Disputes Act, which specifically exclude payment of bonus. In this connection, it is also relevant to refer to the judgment passed by the Honorable Supreme Court, report within bracket 2007, bracket close 5, SCC 281, wherein it has been clearly held that back wages payable under Industrial Disputes Act does not include bonus. In the said case, there was a direction by the Labour Court for payment of 50% back wages, and it has been held that definition of wages within the meaning of the Act does not include bonus. It, however, includes allowances. It has also been observed that the Payment of Bonus Act also excludes bonus for the purpose of calculating the amount of bonus to be determined in terms of Section 10 thereof. In the said case, detailed discussion has been made in connection with entitlement of bonus under back wages, in connection with an award passed under by the Labour Court under Industrial Disputes Act, and after considering all provisions of law, it has been held that bonus is not included in the definition of back wages. This court finds that the learned court has not taken into consideration the definition of wages as defined under Industrial Disputes Act, and therefore on this count the improved judgment suffers from perversity. The direction to give back bonus is also contrary to the judgment passed by the Honorable Supreme Court in the case of Hamdard Work Laboratories. And accordingly, such direction cannot be sustained in the eyes of law, which is hereby set aside. So far as earned leave is concerned, it was objected to by the management before the learned court that since the ex-employee had not worked and therefore there was no question of any earned leave, the learned court has given specific finding in paragraph 14 to that effect, which is quoted as under. This court finds that the said finding and consequent direction does not call for any interference. So far as leave travelling allowance is concerned, specific finding has been recorded in paragraph 15, which is as follows. This court finds that in the definition of wages as defined under section 2RR, the traveling concessions has been specifically included. The reason for opposition of such claim was also only on the ground that the ex-employee did not apply for any leave. This court is of the view that since the ex-employee was out of employment, there was no occasion for them to apply for any leave. And the definition of wages specifically includes the benefit. Therefore, the findings of the learned court with regard to grant of leave travelling concession also does not call for any interference. Consequently, consequently, all the directions except the direction to fix annual bonus at the rate of 8.33% is upheld. This court further finds that the learned court has not quantified the amount paid. 6% interest नहीं मिल सकता. So far as ये हम लोगों ने decide किया है. Interest नहीं हो सकता. It is a certificate issue. So far as direction to pay interest is concerned, the same is squarely covered by a judgment passed by this court in WPA number 6969 of 2017, decided on 19/6/2023. इससे कोई कर लेंगे. And therefore, the direction to pay interest at the rate of 6% per annum is also not sustainable in the eyes of the court. This court further finds that the learned court has not computed the amount payable, and it appears that none of the parties had furnished computation. Accordingly, the provisions of Section 33(c)(2) of Industrial Disputes Act clearly provides under subsection 3 that for the purposes of computation of the money value of a benefit, the Labour Court may, if so think fit, appoint a commissioner who shall, after taking such evidence as may be necessary, submit a report to the Labour Court, and the Labour Court shall determine the amount after considering the report of the commissioner and other circumstances of the case. Even this power has not been exercised by the learned Labour Court. Consequently, this court also finds that under section 33(c)(2), the money is required to be quantified.
AIR 1974, not Supreme Court 1604, it has been AIR 1974.
AIR 1974,
Supreme Court page 1604.
1604. इसका रेफरेंस कोई पैराग्राफ ब्रैकेट में लिख लीजिएगा. AIR 1974 सुप्रीम कोर्ट 1604.
Yes.
पार्टी का नाम
I will give it to you.
ठीक लिख के दे देंगे, नहीं तो पेज नंबर भी गड़बड़ होगा तो
नहीं हम लिख के दें.
In view of the aforesaid facts and circumstances, after having been upheld the finding of the learned Labour Court to the aforesaid extent, this court is of the view that the amount is required to be quantified. The parties are directed to appear before the learned Labour Court, Jharkhand Court, on, I will give a date, after 1 or 2 weeks. And upon their appearance, the learned Labour Court is directed to do the needful in terms of section 33(c)(2) to compute the entitlement of the ex-employee and pass an appeal on this one.
एक मिनट का लिए लिखा दिया है considering in Section 3 if something
Yes, it is also observed that it will be open to the parties to bring to the notice of the learned labour court regarding the payment already made. There is already an observation by this court that the amount paid under Section 47 was required to be adjusted. Any further amount paid thereafter is also required to be adjusted. That's it.
Time frame मतलब क्या है?
The need will be done within a period of 3 months from the date of the reference. इसके अंदर 5 नंबर है ये वाला सॉफ्ट कॉपी
Item 6, WPS 2363 of 2010.
this petition.
Your Lordship will recall that in this case there was talk of settlement. I invite your Lordship to the last order.
Have you filed any reply?
Yes, yes.
I'm extremely
Acceptable, not acceptable.
No, there is no second.
Where is your reply? When did you file your reply?
Yesterday.
Have you received the reply? I don't have a copy right now. What have they said? It is not
They
acceptable.
have made all kind of insinuations against us, but that is besides the point.
Don't bother about it.
It is not acceptable. That is our son. Your Lordship's order last date, your Lordship had recorded everything. If not acceptable, you will call for
Sir,
the
we
lower
will-
court
yes.
records.
We call for the records and decide. Yes, I had indicated. The moment you say no, we will call for the records.
There is no need at all. Not its duties.
Sorry,
It is its duties.
records are not required. We will see the perversity in the award, no? Do you need the records or you don't?
Yes,
The record should be there.
entirely against the police papers. Nothing, no point in it.
What do you
Yes.
want to show from the records? Is there anything which you have not put on record?
No, more or less everything is there, but your Lordship had indicated in the order, so I was saying that if your Lordship can fix a date in the course of argument, if your Lordship finds records are required, then again there will be
No,
another
we will
date.
not do that. Once we start, we start to
That's
finish.
how it
only.
should be. That is how it should be, your Lordship. It will be based on the court's
We'll
standard.
call for the records, get the records. WPL number 2363 of 2010. The learned counsel for the parties are present. The learned counsel for the respondents had submitted that the proposal given by the petitioner is not acceptable to them. An affidavit to that effect has been filed yesterday. Office is directed to trace the affidavit and place it on record. At this, the learned counsel for the petitioner submits that the records be called for from the court concerned for the purposes of final disposal of the case on merits. Office is directed to call for the records from the court of
Legal court, Jamshedpur.
हाँ बताइए केस नंबर बताइए
I got the case number is.
it is you are only aggrieved by the back wages.
My lord, we have paid for the entire PA because now, of course, the respondent workman, the original workman is dead now.
No, you have only challenged the grant of back wages.
No, we have challenged the entire award.
No,
Quashing the award dated by which the petitioner has been directed to give full back wages along with other consequential benefits.
okay, you have challenged the entire
Entire award is challenged.
award का बताइए
My lord.
Of the award passed by Learned Labour Court Jamshedpur in reference case number 19 of 1997, decided on
My lord, this is the date.
12/11/2009. Let this order be communicated through fax. Post this case, final disposal में ही है ना ये?
My lord.
Post this case under the same heading on, बताइए कब करेंगे?
Your lordship, nothing, sir.
19th of December. 19 नहीं हुआ, 19 को नहीं हो पाएगा. 16th of December. 16 December.
My lord. Public.
For orders item 8, the repeal 6695 of 2016.
Yes, petitioner. Who is for the petitioner?
In this, the advocate of the petitioner had died and notices were issued, but as the notice has come now confirmed that the petitioner has also died.
Oh, 1995. Bulla Saw.
No, sir.
This was filed in 2016.
Not sure.
How? How is it possible? We have to dismiss it. There is no option. What was the relief?
Leadership, they had the reference was not answered in their favor petition was dismissed, and against that they have come out.
What was the terms of reference? It was dismissal or what?
Dismissal of leadership. They had impersonated on that basis if departmental inquiry proceedings were held and he was dismissed from the services. Thereafter he had
Now they must have gone to the actual Bulla Saw. That is why he died in 1993. Quite possible.
perhaps leadership, perhaps
Quite possible.
quite possible because both were
If WPL number 6695 of 2016. Nobody appears on behalf of the petitioner. The counsel for the respondent is present. The learned counsel submits that by the order dated 22/10/24, it was observed that by the order dated 2/9/24, it was observed that counsel for the petitioner having expired, notice was issued to the petitioner through speed post. However, in spite of such step, the AD was not received and no fresh wakalatnama was filed on behalf of the petitioner. Consequently, by the order dated 22/10/24, the office of this court was directed to issue notice to the petitioner through the officer in charge of the concerned police station. As per the office note, the service report of the concerned police station has been received, wherein it has been reported that Bulla Saw, the petitioner, expired on 30/10/1995. However, the present case has been filed in the year 2016. The counsel for the respondents has submitted that there was an allegation of impersonation, and it could be possible that the report is in connection with the real Bulla Saw. Be that as it may, since nobody is appearing on behalf of the petitioner and it has been reported that by the police in their report pursuant to order passed by this court that Bulla Saw has expired, this court does not choose to proceed any further in this matter. Accordingly, this petition is hereby dismissed.
Item 9, WPL 4579 of 2021.
Tracking report already,
Sorry?
tracking report of the speed force shows that it has been received, my lord.
Alright. You are?
My lord, in this case,
It is for orders.
my lord, they have not filed counter affidavit till date, my lord. Our court has directed to file the counter, my lord.
यहाँ पे तो ट्रैकिंग रिपोर्ट बोलता है नॉट रिसीव्ड. or received. However, no SR report has been.
Service report.
अच्छा सर्विस कोई बात नहीं. It was issued to respond number 7.
My lord.
Who is respond number 7?
Chief Labor Commissioner.
You will represent Chief Labour Commissioner.
We are representing the company.
You will represent Chief Labour Commissioner. आप लोग आते नहीं है इसीलिए ये सब करना पड़ेगा. क्यों नहीं आते हैं? केस टेकअप होता है तो चीफ लेबर कमिश्नर को तो आप ही रिप्रेजेंट. चीफ लेबर कमिश्नर सेंट्रल. तो बस रिकॉर्ड है ना आपके पास. यूनियन ऑफ इंडिया का तो कैसे नहीं है? यू आर अ पार्टी है. साथ साथ देखिए. हाँ बोलिए. बहस में
My lord, Mr. Subro Sagar will argue in this case, my lord.
वेरी इज.
My lord,
यस.
through video conferencing, please.
तो करें हम लोग वीडियो कॉन्फ्रेंसिंग.
I have called.
You have not given the request.
My lord.
You have not made the request earlier.
Earlier, yes. On the earlier date, my lord.
किसी का रिक्वेस्ट है? Who will argue? क्या नाम बताएं?
Mr. Subro Sagar,
Son of Mr. Layak.
my lord. Mr. Sagar.
What is the matter? आप बताइए.
Your Ladyship, this writ petition has been filed against an order which is annexed at P74, annexure P74, page 253. This is passed by the Regional Labour Commissioner.
Saying what?
The
Oh,
workman has
state
paid
claim.
for
State claim.
state non-implementation of agreement dated 16/3/1972. Now, he has stated that that agreement was not between BCCL and the workman.
How
But
can he
rather-
decide it on merits? State claim is something else. Has he decided it on merits?
He has stated that this is not an agreement in terms of section 18.
Who will decide it? Who will decide this?
He has decided that this non-implementation, the workmen they approached the Regional Labour Commissioner for implementation of the agreement. But he said that this agreement
Read
is
the order.
not
Read the order, please.
subject alleged non-implementation of agreement dated 16/3/1972.
See, it is on merits. You can't decide it. Then you refer to Newbie Bank. You can't decide it. Can you decide it based on merits? Can you decide it?
This has been decided by an officer of the Labour Department, Government of India. And
He is being represented by Mr. Ravi.
yes, so there is an agreement of the year 73.
Whatever we-
Yes.
The law is well settled.
So adjudication is to be done by a industrial tribunal.
Yes. So it was required to be referred.
The
He
ref-
decides the case on merit and at the same time he refers to Newbie Bank.
Yes, ordinarily, on all matters, if it is an industrial dispute in terms of section 2K, then if there is a failure of conciliation, he has to report to the central government,
Yes.
Ministry of Labour,
For reference.
who will take a decision as to whether this requires reference or not. Now, this order, let us see that. And may I read it?
He will be, somebody
What's
else will be appearing, so I was just wanting. कब
No, this
आएंगे
is the-
बताइए?
only
कल आएंगे?
कल तो छुट्टी है परसों.
Next week.
मंडे को रखें 2:15 बजे. If you will not join, you are. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that improved order refusing to defer the dispute for adjudication has been passed on merits, and therefore it calls for interference. However, she submits that the matter has to be argued by Mr. Subro Sanyal, spelling लिख के दीजिए, who will join the court proceedings through this. लास्ट में एक सुप्रीम कोर्ट का क्या ऑर्डर लगा है?
इसमें तो हमारे हाई कोर्ट के इसी फाइल में 8 केसेस का रेफरेंस है, तो आपको वो 8 देखना पड़ेगा. It starts from CWJC number 3280 ends up in LPA 182 of 2000. इस बीच में there are 8 cases which they have enclosed in other orders are there. So,
For reference.
no, not for reference. This matter has travelled to this court for on different issues relating to this. There are 8 cases.
Pose this case on next Tuesday in the supplementary cause list to be taken up at 2:15. इसमें लिखेगा at the request of the petitioner. The counsel for the petitioner is directed to submit. The parties are directed to submit short synopsis of arguments latest by Monday. Latest by Monday 5 o'clock. रात को 5 इसका रिकॉर्ड तो कुछ होगा ही नहीं, बस यही
इतना ही है. Unnecessarily filing counter affidavits is of no use.
कोई फायदा नहीं है, वो इंक्लूड ऑर्डर ही देखेंगे. थोड़ा सीक्वेंस बना दीजिए.
हाँ, सीक्वेंस में
ठीक है,
जितने केसेस फाइल किए हैं उसका खाली दे दोगे तो होता है.
थोड़ा सीक्वेंस चाहिए क्योंकि ऑर्डर लिखाने के लिए सीक्वेंस सही होना चाहिए.
For admission attempted, WPC 3490/2018.
एक चीज और लिखिएगा. The notice issued to the respondent number 7 था. Respondent number 7 को नोटिस हुआ था. Respondent number 7 through speed post appears to be validly served as per tracking report and mentioned in the office note.
So this is a matter.
अपने appearance memo. Counsel for the respondent number 7 is present.
This is a matter which has been held way back in the year 2018. It relates to payment of due monetary compensation to the tune of rupees 9 lakhs and odd. There are certain, this case has a checkered history. I should take your leadership to certain orders. At Annexure 1, that is the page number 12, order passed.
Is it arising out of compensation?
Yes, it is arising out of compensation,
Under which act?
land acquisition.
Land Acquisition Act. NHAI नहीं है. NHAI नहीं है.
इसमें जो Annexure 1 पेज 12 है,
हाँ.
एक बार देखा जाए. पैरा नंबर 3, एक ब्रीफ इससे पता चल जाएगा मैटर का. I may be allowed to place. Annexure 3, Annexure 1, page 12, third paragraph. In view of the said submissions, the read petition is disposed of with a liberty to the petitioner to file a detailed representation along with supporting documents before DC Ranchi. On receipt of the such representation, the DC Ranchi shall himself or through any competent authority get the petitioner's claim examined and thereafter pass appropriate reasoned order within 6 weeks from date of receipt of the representation. Next page. If the petitioner's claim is found genuine, the same shall be referred to the appropriate authority for due assessment of the amount of compensation and for payment thereupon to the petitioner. Now, your leaderships, after this order, nothing was done by the respondents. Thereafter, Annexure 2, that is page number 15, contempt was filed. The fourth paragraph of the contempt.
On the basis of the above said submissions made by land council for the opposing parties and the stand taken in show cause, the contempt petition is disposed of at this stage. However, with observation that compensation which is found due upon completion of the land acquisition process be paid to the petitioner in terms of the judgment under offence as expeditiously as possible. Contempt stands disposed of. Thereafter, your lordship would come to annexure 3, that is the page number 16. This is a letter written by the कार्यपालक अभियंता to the DC. विषय is important. माननीय झारखंड उच्च न्यायालय में दायर कंटेम्प्ट सच एंड सच सृष्टिधर महतो बनाम झारखंड सरकार के आलोक में रहती भूमि के मुआवजा हेतु ₹9 lakhs and odd का भुगतान करने के संबंध में प्रसंग आई एम स्किपिंग रेफरेंस ऑफ लेटर्स एंड महाशय उपरोक्त विषय प्रसंगित पत्र की ओर आपका ध्यान आकृष्ट करते हुए सूचित करना है कि आदेशानुसार
आपको क्या बोलना है?
We have to say that so far as the amount is concerned, the petitioner is entitled to receive the sum of 9 lakh rupees, 20,785 rupees. Plus, it has to be sanctioned. It has to be disbursed in favor of the petitioner. Plus, in recently, a supplementary affidavit has been filed by the petitioner, wherein they have stated that they have now rectified. They have opened a joint bank account, which was earlier restricted. The payment was not being able to made by check. Hence, this letter was issued. That is annexure 3. Now the joint account has been opened, so the impediments in payment is now cured. The amount will be transferred to the petitioner.
ट्रांसफर करके आइए। ट्रांसफर करके आइए।
4 weeks.
2017 से चल रहा है, ट्रांसफर करेंगे, इंटरेस्ट के साथ ट्रांसफर कर रहे हैं आप।
इसमें इनसे हम लोग मांगे थे कागज।
लीडरशिप इसमें सर्टेन गलतियां हम लोग के एंड से भी हो गई थी। जब ये लेटर हम लोग को मिला तो हम लोग को ये सारा डॉक्यूमेंट्स उसी समय कंप्यूटेड अथॉरिटी के समक्ष फाइल कर देना चाहिए था, ब्लैंक चेक और ये कैंसिल्ड चेक और पैन।
Now there is no impediment in making payment. You pay इनका।
इसको डिस्पोजल कर रहे हैं।
डिस्पोजल नहीं करेंगे इसको।
At least 3 weeks may be granted. Do the needful and make the payment.
लैंड एक्विजिशन का ऐसा मैटर डिस्पोजल नहीं करेंगे। पेमेंट करना है तो पेमेंट करके आइए। क्योंकि फिर कंटेम्प्ट होगा, फिर आप एक और लैकुना इसमें लगाइएगा।
इसमें क्या हुआ था कि रीड पिटिशनर ने जो सॉलिसिटर तो है ड्यूरिंग प्रेगनेंसी ऑफ रीड ही डाइड, हम लोग ने आगे फाइल करके उनके लीगल हेड्स को सब्स्टिट्यूट कराया था। तो वी विल फाइल अ फ्रेश रिप्रेजेंटेशन और वो क्लैम ये जो चेक बोल रहे हैं, चेक तो फाइल करना पड़ेगा हम लोग को इनके पास। Thereafter, we have mentioned in our supplementary affidavit, that is the annexure is page number 4 of the supplementary affidavit. Joint account widow along with the 3 children. एक bank account हम लोग ने खोला है और the amount needs to be credited in that account.
देखिए, WPC number 3490 of 2018. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the amount of compensation payable to the petitioner in connection with the land has already been quantified. As is apparent from letter dated 13/6/2017 annexed along with the writ petition. But the payment was not being made, and accordingly the present writ petition was filed. He has further submitted that during the pendency of the writ petition, the petitioner expired and has been substituted
By order dated
by order dated 21/3/2024. Petitioner expired on 27/2/2023 and has been substituted by order dated 21/3/2024. He has also submitted that a supplementary affidavit has been filed, bringing on record the joint bank account opened in the name of the widow of the petitioner and 3 children, namely Santosh Kumari, Santoshi Kumari, Sakhi Devi,
and Saraswati Kumar.
Saraswati Kumari and Devki Devi.
Worship, एक चीज इसमें बता दें. Sakhi Devi is the wife of the petitioner.
Namely, Sakhi Devi, wife of the petitioner, Devki Devi, Saraswati Devi and Santoshi Devi.
Saraswati Kumari.
सरस्वती देवी लिखे आप इसमें सब्स्टिट्यूशन में आपका वही ना
एफिडेविट में पैरा 4 देखा जाए आईए में सब्स्टिट्यूशन
आपने सब्स्टिट्यूशन में तो संतोषी देवी लिखा है
वो ऑफिस को डायरेक्शन दिया था करने के लिए मैंने नहीं किया आईए से एक बार देख लिया जाए आईए पैरा नंबर 4
संतोषी कुमारी भाई ये
ये
ठीक
संतोषी
कराइए जो भी यहाँ पे किए हैं उनको बुलाकर संतोषी देवी नहीं होगा संतोषी कुमारी होगा सखी देवकी देवी सरस्वती कुमारी एंड सरस्वती हाँ ये इसे ठीक कराइएगा है ना बुला के ठीक कराइए
आईए के पैरा नंबर 4 में
हाँ।
सारी चीज लिखा हुआ
हम करवा लेंगे The learned council submits that the details of the bank account has been disclosed in the supplementary affidavit and this petition may be disposed of with the direction to respondent number 2
Deputy Commissioner
to
answered.
remit the payment. Council for the state has submitted that as per their counter affidavit, you have not filed any counter affidavit. Land acquisition में ऐसा नहीं ट्रांसफर
लास्ट चांस हो गया था लेकिन उन्होंने फाइल
लास्ट चांस चाहे कितना भी चांस हो जाए यहाँ पैसे का पेमेंट ऐसे नहीं चाहिए no counter affidavit has been filed in the present case. Council for the state is directed to in such circumstances, this writ petition is disposed of, enabling the petitioners to approach the respondent number 2 by filing a representation and with appropriate documents regarding their identity. Along with a copy of the writ records. Upon filing the representation, the respondent number 2 is directed to pass a reasoned order, and if there is no legal impediment with regard to payment of the amount which has already been quantified as contained in
Annexure 3.
3, the amount be remitted in accordance with the amount be remitted within a period of 2 months from the date of receipt of the representation. ठीक है?
Next.
Item 11, WPC 646 of 2019.
Last date, petitions were directed to bring on record by way of supplementary affidavit regarding the ownership of land of the petitioners. It has been filed yesterday. Total 8 petitioners have land which is acquired by the state.
This was directed by the order dated. Where is the description? Where is the description? What affidavit have you filed? ये क्या है? किस तरह का affidavit है? No supporting document.
Ownership has already come in notification itself. It is admitted that our land has been acquired.
So why you are seeking compensation?
No, Lordship. I am seeking the quashing of entire land acquisition process because it is against the Land Acquisition Act of 2013. It has been acquired by the state, but there is no public purpose in that acquisition, and several sections have not been followed, including Santal Pargana.
What was the? This is Adani Thermal Power.
Yes, of course. There is no public purpose in it.
The power plant has been installed, established.
During the pendency of this. There was an order to file counter affidavit, but it has not been filed yet. On 13 February 2020.
When were you dispossessed? What is the date of dispossession? Have you been paid any compensation?
Yes, I have been the compensation have been deposited without my consent to the accounts of.
Have you taken it or you have not taken it? Have you taken the compensation or you have not taken
I
the
have to
compensation?
take instruction on that
What instruction?
because.
Because means what? If you have already taken the compensation,
But
now you want that
but
it has to-
several laws have been violated without any.
This is not a public
follow-
interest litigation. Are we dealing with that?
But the law has to be followed
Law has to be
during
followed.
during
Then you
every
should not have
proceeding.
taken the compensation.
If law, I have to take the instruction on that.
The learned counsel for the petitioner submits that a supplementary affidavit has been filed giving the details of the land in connection with each of the petitioners. However, no supporting documents have been filed along with the supplementary affidavit. To this, the counsel for the petitioner submits that it is not in dispute that he submits that from the records of this case it can be demonstrated that that there is no dispute in connection with the amendments made in the supplementary. He has further submitted that during the pendency of this case, the power plant has already been established and the petitioner's power plant has already been established. The learned counsel further submits that he is not aware as to whether the petitioners have received the compensation amount or not. And accordingly, he seeks adjournment to bring this aspect of the matter on record. डेट के साथ लगाइए, डेट के साथ रखिए लगाइए, कॉम्पनसेशन वाली बात. उसके बाद आपको सुनेंगे तब काउंटर करिएगा. आप समझना होगा ना पब्लिक पर्पस किसको बोलते हैं. Export is not a public purpose.
No, because it is privately owned company.
प्राइवेटली ओन्ड ही होगा ना. गवर्नमेंट तो कर ही नहीं पाती है सब काम. उनके बस का ही नहीं. झारखंड सरकार ने एक भी पावर प्लांट लगाया है जो वर्ल्ड लेवल काम कर रहा है ना. आधा दिन लाइट
NTPC.
झारखंड सरकार की बात कर.
Because the law should be followed. I am not against any acquisition or development.
आप अपना एफिडेविट फाइल करिए तब सोचिए. लेकिन आप तैयार होके आइएगा पब्लिक पर्पस पर. यू आर फॉर द स्टेट, फॉर यूनियन ऑफ इंडिया. आप क्या कर रहे हैं? स्टेट कौन? स्टेट का where is the state? State is a party. Where is the state?
He hasn't served. No, name is
Who is
appearing.
counsel for the state over here? आप एफिडेविट फाइल करिए. चलिए.
Time 8 weeks time will be given.
The council pays for 8 weeks. Second week January.
Okay.
Item 12, WPC 6823 of 2019.
Yes,
Direction was given by to the honor Shuri Tiwari by the learned tribunal in the accident claim case. The direction was given to the owner of the truck to make payment of the amount of compensation, but the petitioner has no concern in any manner. In spite of that, the proceeding.
Surety.
बस surety.
क्या बोलना है?
और भी ट्रक रिलीज के समय थाना में किसी कोर्ट से भी कोई ऑर्डर नहीं था कि ठीक है जब जरूरत पड़ेगा तो हम बताएंगे कि ट्रक कहाँ है.
Petitioner stood as a surety at the time of release of vehicle cards, and thereby in the certificate case he has filed objection under section 9.06, which has been rejected. So and he can prefer appeal under section 62.
You have filed your objection.
Objection, yes.
Who are you?
I appeal from the sides of the private respondent.
Truck owner. 40% ये तुमको जमा करना होगा. यहाँ ऑल्टरनेटिव रेमेडी जिसका कोई लायबिलिटी नहीं है.
कोई लायबिलिटी
कैसे चलेगा?
हम आगे पिटीशन फाइल किए मान लो कि उनका जो कॉन्सेस है उसको पार्टी बना दी. उनका जो लीगल रिप्रेजेंटेटिव है उनको नोटिस कर दिया.
इनका लीगल रिप्रेजेंटेटिव
ये इनका किशोरी तिवारी.
किशोरी तिवारी कौन है?
ऑनर ऑफ द ट्रक.
आप ही है ना ऑनर ऑफ द?
नहीं, हम प्राइवेट रेस्पोंडेंट हैं.
प्राइवेट रेस्पोंडेंट.
हम हैं उनकी तरफ से. व्यक्ति प्रमोद साहब.
किशोरी तिवारी के बिहाफ में प्रमोद पांडे के अगेंस्ट में ऑर्डर हुआ, रामनाथ पांडे के, अब उनके बिहाफ में
वो उसमें टाइटल एक्सीडेंट के लिए में नहीं ऑर्डर हुआ है, उसमें ऑर्डर हुआ है हमको पेमेंट करने के लिए, लेकिन हमको इसमें मेरे ऊपर में केस चला दिया।
कहाँ है आपका ऑर्डर, कहाँ आपका ऑब्जेक्शन, कहाँ आपका सियोरिटी का डॉक्यूमेंट कहाँ है? आपने कोई डॉक्यूमेंट फाइल किया होगा ना सियोरिटी का, कहाँ है
क्या उपस्थित करेंगे, बस इतना ही लिख के
कहाँ है?
तो ऐसे 2 सप्ताह का टाइम चाहिए था हम
बस
लोग को,
आपको
सर
खाली टाइम चाहिए,
वो छुट्टी में चले गए थे बाहर।
कोई बात नहीं, अब आप जाके अपनी फाइल करिए, आपको बहुत टाइम
नहीं
मिलेगा।
नहीं, बस इसमें कहीं ना कहीं है,
क्या
दिखा
बोलिए?
देते हैं वो कागज है कहीं, अब फाइल किए हुए हैं।
सियोरिटी में टर्म्स एंड कंडीशंस होगा ना, एम आई करेक्ट?
तो
क्या टर्म्स एंड कंडीशंस?
दिखा देते
ट्रक प्रोड्यूस करेंगे कि उसका पैसा पेमेंट करेंगे,
दिखाते हैं।
और कितना का सियोरिटी?
वो सिर्फ ट्रक रिलीज के समय हुआ था कि हम ट्रक को उपस्थित कर देंगे, ट्रक को मैं अपनी जिम्मा
अब
पर
कहाँ से आप रिकॉर्ड से दिखाइए, अपने पॉकेट से कागज निकाल के मत दिखाइए, हमने देखते हैं
किसी की तरह से काउंटर जो फाइल किया उसमें
काउंटर में है।
But also on the last occasion, petitioner was directed to bring on record by way of supplementary affidavit.
Have you brought on record?
There was oral direction.
Oral direction. Oral direction.
ये देखिए,
आपका वो डॉक्यूमेंट हम ऐसे नहीं देख सकते, सियोरिटी वाला डॉक्यूमेंट कहाँ है, किसके पास होगा?
काउंटर में सिर्फ पेज नंबर 13 देखा जाए एनेक्सर 1 को,
एक कॉन्ट्रैक्ट फाइल किया गया है ऑन बिहाफ ऑफ द रेस्पोंडेंट नंबर 4, पेज 14 में एक अपना कंप्रोमाइज हुआ है, उसमें बोले हैं कि हमने पैसा पेमेंट करेंगे।
ट्रक की संबंध में एक्सीडेंट के लिए कुछ नहीं, वो पेज नंबर 13 देखा जाए मान लो,
पेज नंबर
ऑर्डर डेटेड 15/11/2019 का ऑर्डर है। अब ये
पैसा पेमेंट करेंगे किसके बारे में?
पैसा का पेमेंट हम नहीं करेंगे,
रामनाथ पांडे बोले
सिर्फ ट्रक रिलीज करेंगे।
कंप्रोमाइज पिटीशन लगा हुआ है पेज 14 में, काउंटर एफिडेविट ऑन बिहाफ ऑफ द रेस्पोंडेंट नंबर 4, पेज 14 एनेक्सर बी है। लोक अदालत में दे है द मैटर हैज बीन कंप्रोमाइज्ड।
This is a compromise between the certificate holder and Ramnath Pandey. You are Ramnath Pandey? पता ही क्या है? Ultimately क्या हुआ इसमें? Compromise का order कहाँ है?
ऑर्डर कुछ नहीं हुआ, उसके बाद इन लोग मीटिंग रह गया, कंप्रोमाइज हो गया, कंप्रोमाइज आ गया है।
कुछ तो नहीं, ऑर्डर कुछ रहेगा ना कोर्ट का,
इसका कोई कोर्ट का ऑर्डर होगा ना, compromise accepted, rejected?
कुछ भी नहीं, सर कुछ कोई ऑर्डर नहीं।
लोक अदालत में भेजा जाए लिखा, फिर गया था लोक अदालत में मैटर?
लोक अदालत में ही गया था, वहाँ से हुआ कि लोग पेमेंट करेगा और पेमेंट किए नहीं आज।
कहाँ है?
ऑर्डर तो आया नहीं, देखो बताइए। इसके बाद
जब इनका लीगल एयर्स लीगल रिप्रेजेंटेटिव जब इनका है, उसका एड्रेस हम दे दिए लॉर्डशिप, आइए फाइल करते हैं, तो
ट्रैक का आपने रिलीज कराया और आपने
क्रिमिनल केस में रिलीज करा दिया।
इंश्योर किया कि जब जरूरत होगा हम
ट्रक-
कैश देंगे,
ट्रक-
और नहीं देंगे तो फिर हम
यह
1
सब
लाख
इतना ही
रुपए
था,
देंगे।
सिर्फ ट्रक के लिए था बस, वो चीज की
वो कहाँ है वो डॉक्यूमेंट? आपका सियोरिटी वाला डॉक्यूमेंट कहाँ है? दैट इज अ बेसिक डॉक्यूमेंट। व्हाट वाज योर अंडरटेकिंग?
एक पेज मेरे पास आया लास्ट में, लेकिन वो प्लेन पेपर में था, उसी का पेपर।
ट्रक का मालिक मैं रामनाथ पांडे, मेरा पास फाइल तो नहीं है, लेकिन ये है एक डॉक्यूमेंट।
ट्रक प्रोड्यूस करने का आपको एक जिम्मेवारी था ना?
जी,
प्रोड्यूस कर दीजिए, ट्रक फिल्म बेच के रियलाइज कर, ट्रक प्रोड्यूस कर दीजिए, बेच के रियलाइज कर।
उसका जो लड़का लोग है वो लोग को जरा नोटिस कर दिया जाता, पता चल जाता ना।
नहीं नहीं, आप ही का
ऐसे नोटिस करके यहाँ पे हम लोग यहाँ पर क्या करेंगे?
आइए पिटीशन फाइल तो किए ही हैं।
आपको ऑर्डर हुआ है ना नीलामी पत्र का, आप इसमें अपील फाइल करिए, कुछ नहीं हो सकता।
हमको ऑर्डर हुआ है, अभी तो पता नहीं कहाँ पे
है तो एनेक्शन लगा हुआ है, एनेक्शन 1
वो इतना ही हुआ है, लेकिन कोई फाइनल अभी तो नहीं हुआ है।
क्या फाइनल हो गया? आपने 11/12/19 को फाइल किया है और 15/12 का ऑर्डर है इसमें इलेक्शन ए to the counter affidavit filed by
एक डेट फिर हमको मिल जाता ना तो हम पता
respondent number 4 के counter affidavit में ऑर्डर का कॉपी लगा हुआ है। ठीक है, देखिए
जब इनका लीगल ये रिप्रेजेंटेटिव है
आप जाइए,
तो
आप-
इनको इन पर सर्टिफिकेट केस
हम
नहीं
नहीं
चलना
जानते,
चाहिए।
आप सारे डॉक्यूमेंट्स भी नहीं लेके हम लोग कुछ नहीं कर सकते। देखिए
ये तो मेरे पास
कुछ
डॉक्यूमेंट को
कोई
ये है।
WPC number 6823 of 2019
एक डॉक्यूमेंट
और
है
the
मेरे
learned
पास।
counsel for the parties
स्टे भी मिला था, वारंट
आप
हुआ
बस
था तो स्टे भी मिला।
सुनिए, और the learned counsel for the parties this writ petition has been filed for the following relief. You are for respondent number 4.
I am for 123.
A counter affidavit has been filed on behalf of respondent number 4 indicating that the objection filed by the petitioner in the certificate proceedings has been dismissed by the order dated 15/11/2019. The same has been annexed as Annexure A to the counter affidavit filed by respondent number 4. He submits that the petitioner has an efficacious remedy under the provisions of Bihar and Odisha Public Demand Recovery Act by filing an appeal. And in the present case, neither the order dated 15/11/2019 has not been challenged, although the same has been passed prior to the filing of the writ
डायरेक्शन के
petition.
भेजा
Prior to the filing of the writ petition
वहाँ पर
on
जाइए।
11/12/2019. The counsel for the state has submitted that the petitioner may avail the alternative remedy of appeal, and multiple questions which are disputed are involved in the present case. Even the nature of surety of the petitioner has not been brought on record. Correct? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the objection filed by the petitioner has been rejected by the certificate officer by the order dated 15/11/2019 as annexed along with the counter affidavit filed by respondent number 4. But the writ petition was filed
in the year 2019.
on 11/12/2019 stating that the petitioner has filed objection under section 9, stating in paragraph 15 that the petitioner has filed objection under section 9 of Bihar and Odisha Public Demand Recovery Act on 21/10/2019, but the certificate officer is not disposing of the objection. And a warrant of arrest has been issued in the certificate case. The order rejecting the objection having been brought on record, which is dated 15/11/2019, this court is not inclined to proceed any further in this writ petition, as the petitioner has an appropriate remedy of appeal before the appellate authority. The petitioner may file accordingly, this petition is disposed of, enabling the petitioner to avail the alternative remedy within a period of 1 month from today. This order can be within a period of 1 month from today.
Actually, he is struggling between life and death always. इसका एज बहुत ज़्यादा है, about 80 years. इसलिए ये 1 month से ज़्यादा कर दिया गया।
कितना कर 2 months? 2 months for
तो लगता है कि वो चलने फिरने में भी असमर्थ है.
If the appeal is filed within the aforesaid time frame, the appellate authority shall consider the matter on merit. नहीं उतना मत कीजिए. That should be sufficient. The state petition is accordingly disposed of. The appeal, if filed in as per the provisions of the Bihar and Odisha Public Demand Recovery Act, be decided expeditiously.
Item 13, WPC 3550 of 2020.
Yes, petitioner.
This case of at 7 Texas 6 where the Lordship has passed the order, vacate the shop in question, Your Lordship. In the last
Who has passed the order to vacate?
Kindly
ये
see
तो
the
सुना हुआ है.
5 हाँ जो सुबह इसमें हुआ था
क्या हुआ था? Last time क्या किया?
हाँ इसमें एक
है 28/10 का कोर्ट ऑनरेबल कोर्ट है मतलब आज एन ऑर्डर फॉर एन इंक्वायरी अपॉर्चुनिटी हैज बीन गिवन टू बोथ रिपोर्टर्स para 5 lordship asked us to file a supplementary affidavit that if the shopping complex is made whether we are agreeable to allot them.
Yes.
Yes, we have agreed.
क्या करना?
my submission that also for the para 5 is concerned to see this it appears that they want to throw the petitioners on road, Your Lordship, because
देखिए घर
nothing
खाली होगा तभी ना नया घर बनेगा.
हाँ तो ठीक है जो टाइम खाली फ्रेम कर दे कुछ बस और कुछ नहीं चाहिए
कितना दिन में आपका
हाँ, बस
कंस्ट्रक्शन
और कुछ नहीं
लगेगा?
टाइम फ्रेम
टाइम फ्रेम कर दिया जा
हाँ,
सकता
बस
है
और कुछ
लेकिन हम लोग आके रिक्वेस्ट कर लेंगे अगर मान लिया नक्शा पास होने में देर होता है
तो
आजकल
कुछ एक्सटेंशन का जरूरत
ईसी
होगा
भी
तो
लेना
कर लेंगे.
पड़ता है
ठीक है.
आजकल ईसी भी लेना पड़ता है
एफिडेविट का ईसी भी लेना पड़ता है क्या?
हाँ ईसी लेना पड़ता है आजकल हाँ
फॉर स्मॉल कंस्ट्रक्शंस आल्सो.
मतलब ये बड़ा
बताइए कहाँ लिखे?
मतलब पैराग्राफ नंबर 5 of the affidavit which we have filed.
बस हो गया. पैरा 5 इनका कोट करके डिस्पोजल कर.
हाँ जो टाइम उसमें फ्रेम नहीं है लिखा हुआ इसलिए हम
कोई बात नहीं. टाइम फ्रेम आपको कितना
रीजनेबल
लगता है?
टाइम
कितना टाइम
बोलिए
लगेगा?
टाइम
नहीं नहीं
6 महीना में कहाँ से बिल्डिंग बन जाएगा
6 महीना में पूरा एयरपोर्ट बन जा रहा है. बोलते
अब बोलिए ये लोग कहाँ से बट मतलब जो आपको अच्छा लगता है हम कुछ बट दे आर बीइंग फेयर आई सजेस्टेड देम यस बल्कि हम ये भी लिखे हैं कि मॉनेटरी मांगते हैं कॉम्पेंसेशन वो भी देंगे सुप्रीम कोर्ट अदरवाइज कहता है कि अगर डिलैपिडेटेड बिल्डिंग है इट शुड बी डिमोलिश्ड दैट इज व्हाट सुप्रीम कोर्ट हैज सेड बट स्टिल वी आर एग्री
आपको मॉनेटरी कॉम्पेंसेशन चाहिए कि क्या चाहिए?
नहीं जो हमको
दुकान चाहिए ना?
हाँ जी
वो तो एक परमानेंट सोर्स ऑफ इनकम
जी लाइवलीहुड उसका है 20 साल से चल रहा है
अभी आपका क्या स्टेज है? इनको कर चुके हैं already?
नहीं
नहीं कर रहे.
नहीं खाली
वो तो
आप खाली कब
बिल्डिंग
करेंगे?
डिमोलिश का ऑर्डर
जैसा जो आदेश होगा हम
नहीं नहीं आदेश नहीं. आप हमको बताइए कितना दिन में खाली करेंगे तो हम आपको इंस्ट्रक्शन लेके बताना है. ऐसे
सर आई विल टेक इंस्ट्रक्शन लॉर्डशिप एक डेट दीजिए हम पूछ लेते हैं कितना
आप
दिन में
डेट
खाली
आपको चाहिए.
कोई भी एक डेट जो
आपका पिछले डेट में लिखा हुआ है ना ऑर्डर दैट यू आर विलिंग टू इविक्ट.
हाँ सब ये लोग इसके लिए राजी हो गए थे जो टाइम फ्रेम कर देंगे तो हम खाली कर देंगे तो हम मुझे पूछ लेते हैं कल भी रख देंगे कुछ परसों हमसे पूछ लेंगे कि भाई कितने दिन में खाली
हाँ प्लीज थोड़ा सा
हम पूछ
पूछ
लेंगे
लीजिए.
हाँ
इसको
ठीक है
सुचारू रूप से आगे ले जाते
नहीं ठीक है वो एक डेट
हैं
फिक्स
कि आगे कोई कॉम्प्लिकेशन नहीं.
जी जी
आप भी थोड़ा पूछिए कि कितना टाइम लगेगा कंस्ट्रक्शन में जनरली.
ठीक है
एक बार को कुछ टाइम फ्रेम देंगे अगर मान लीजिए कुछ
हाँ,
एक्सटेंशन
extension
चाहिए तो आ जाइए.
हाँ
हाँ ठीक है
कोई नहीं
WPC नंबर 3550 ऑफ 2020.
हम इसको एक प्रपोज करें जो हम प्रिलिमिनरी बात किए थे अगर ये लोग 2 महीना में खाली करेंगे 2 महीना रीजनेबल लोग तो कम बोलता था बोले नहीं 2 मंथ्स टाइम लगेगा 2 महीना में ये लोग खाली करेंगे उसके बाद 1 साल का टाइम दे दिया जाए और कंप्लीटिंग कंस्ट्रक्शन जरूरत होगा तो ही हम
कंप्लीटिंग एंड गिविंग पोजीशन.
हाँ Yes.
But before giving possession to anybody else, कम से कम इनको आप adjust करें.
हाँ 100%. हमारा फाइल में हम लिखे ही है कि मतलब हम देंगे और उसमें कोई दो
एक 2 महीना टेंटेटिव लिखें तो डिस्पोजल कर देते हैं इसको.
तो बेहतर है. क्या पॉइंट?
थोड़ा सा अगर 2 मिनट हम
आप बाहर पूछ के
हाँ,
आइए.
जी,
आप
हम-
किसी आदमी से पूछ के आइए ना.
हाँ, जी, हम
कर
2
देंगे
मिनट-
इसको अननेसेसरी
जी, जी,
पर्सनल
हम
रखने से
दो
क्या
मिनट
फर्क.
हम पूछ
आप पूछ के आइए.
हम लोग को भी दिक्कत होता है कभी वहाँ फंस गए कभी यहाँ फंस गए.
नहीं होता. 2 महीना में अगर मान लीजिए आप खाली करते हैं तो
3 महीना भी ले सकते हैं ऐसा कर
पूछ लेंगे ना कितना टाइम.
Item 14 contains civil 345 of 2024.
Petitioner.
As per the last order,
क्या हुआ?
respondent is directed to file supplementary counter application. But till there was no supplementary so called
I apologize that it could not be filed the supplementary so called.
Why? Why was supplementary show cause required?
Because the query was raised by this honorable court that the inquiry report suggests that there is certain encroachment, but the reason order which has been passed by the deputy commissioner says that there is no encroachment. So if it is based on the inquiry report, how can there be a disparity between the two?
So how much time do you need for a supplementary show cause? अब तो
Two
इलेक्शन का काल ही चल रहा है.
हम बात किए तो चिट्ठी भी लिखे हमारा इलेक्शन. I must not say that.
कौन देंगे सप्लीमेंट्री शोकेस? कौन फाइल करेंगे?
पार्टी है.
डीसी पार्टी. Learned counsel for the parties are present. Counsel for the opposite party representing the Deputy Commissioner Ranchi, Palamu. Representing the Deputy Commissioner Palamu, prays for 2 weeks' time to comply the order dated 8/10/2024, whereby a direction was issued to file supplementary show cause by 29th of October 2025. Time as paid for is granted. Holds this case on November 24. The supplementary show cause be filed by 27th November. Also supplementary list.
Item 15 contains civil 845 of 2024.
Payment has been paid, Malaysia, and the supplementary cause is also ready.
Payment हो गया?
Yes.
Content civil 845 of 2024. Counsel for the parties are present. Counsel for the petitioners submit that the petitioner does not have any surviving grievance. Supplementary show cause, and the counsel for the opposite party files supplementary show cause.
It is not, it has not been filed, it is ready, may be taken, but if
File supplementary show cause, we just take it on record. नहीं तो आपका फीस कैसे बनेगा? Right? इसीलिए जरूरी है. चलिए. Considering the submissions of the petitioner, this court does not choose to proceed any further. This continues to be submitted.
Obliged.
From daily list for final disposal items with WPC 2623 of 2021.
Yes, petitioner.
Leadership on the last occasion, the state undertook to file a counter affidavit. This is the matter pertaining to the acquisition of land in the widening of the NH division in Kodarma, in which your leadership have already granted a status quo order.
Mandamus. You are seeking a mandamus. They were directed to file any counter affidavit.
State is directed to file a counter affidavit.
Yes. Status quo. Where is the state? They were supposed to file counter affidavit. Were they?
Leadership, in this matter, they have served us a copy of IA.
IA for what?
They might have be filing today itself. Morning itself, they have served upon us, asking for some time to comply with the previous order and so on. They need to file the response. Order dated is 9 September 2024.
9/9/24. There is no interim order. It is
Interim order, the
clarified-
last occasion, last leadership has extended.
It is clarified that no interim protection has been granted in order
That is-
dated 9/9/24.
There is leadership has granted the status quo order. Later on.
Can you see order dated 16/10/24? Interim protection was granted by order 3.
Yes, madam, what is the situation?
I don't know if the state has to verify whether the land is acquired or not acquired and what extent the land is going under the hand.
The road is constructed already.
No,
It is under construction.
Service road is pending.
Service road.
On 17/10/2024, apparently state had held a high committee meeting, Leadership.
Yes, madam, a high committee meeting has been held. You are seeking time to file a counter affidavit.
Yes, Your Ladyship. We have filed one IA.
IA for?
For
IA number?
12131 of 24.
12131 of
12131 of 24.
24.
For extension of time by 8 weeks for complying the order.
8 weeks.
Yes, Your
Your
Ladyship,
service
because-
road will not be functional. You don't want it to function.
Your Ladyship, because of election we need.
Because of election, you don't need road. What an excuse of this nature.
Your Ladyship, there was a meeting held in 14/24, 9 and on 16.
WPC number 2623 of 2021. Council for the parties are present. Council for the state submits that IA number 12131 of 24 has been filed, seeking extension of how many?
8 weeks.
8 weeks time to comply the order dated 9/9/24 and file a counter affidavit. She has submitted that on repeated occasion. High level meeting has already been
Yes, Your Ladyship, Deputy Commissioner has been directed to constitute a committee to conduct physical verification for that.
She submits that on account of ensuing election, the matter could not be taken up any further and therefore extension of time may be granted. At this, counsel for the petitioner submits that the interim order granted in their favor be extended. Considering the submissions, post this case on post 15th January रख देते हैं. 8 weeks कब खत्म होगा? Second week January. Post this case on 8th of January 2024. The supplementary counter affidavit, the order of this court will be complied by the state by 7th of January. The interim order.
3rd October is the interim order.
Sorry?
3rd October is the interim order.
The interim order dated 3/10/2024 is extended till 8th of January. And whatever you do, you call the petitioner also. Measurement कराएंगे, on the spot जाएंगे, उनके absence में मत करिए. नहीं तो फिर कहानी शुरू हो जाएगी. Same story will be repeated.
Will inform them.
हाँ, you should inform them. Circle officer ही तो जाएंगे. Deputy commissioner थोड़ी इंच टेप लेके जाएंगे करने. हाँ, तो उनको You take them into loop. क्या हुआ?
Also decided 13 from supplementary list.
उसमें एक से बात हुआ, बाकी लोग से बात नहीं हो पा रही है। वो कह रहे हैं कि हम एक दिन हमको समझिए, तो डे आफ्टर टुमारो जो उसको
Counsel for the parties are present, post this case day after tomorrow. At the request, post this case day after tomorrow to be taken up at first case at 10.
ऑलराइट।
इनका इंस्ट्रक्शन तो ऑलरेडी है।
हाँ हाँ जी।
Item 4 from the list WPL 6680 of 2023.
Yes, petitioner.
Last quarter में ACR got called.
ACR has come. आगे चलिए, बहस करिए.
Yes. Annexure 3 is the award for the Leonard Goodman, by which a direction has been given to us to give appointment to the son of the deceased employee of Kashmir. The case of the management is that the ex-employee had himself obtained employment on the basis of fraud, and the complainant is none other than his father, who says that he is not my son, but the son-in-law, my son-in-law.
So as a son-in-law, he is not entitled.
He is not entitled. And the complainant is the person whose land has been acquired by BCCA, and he says that he is not my son, but my son-in-law. Now, can we see the stand of the
So let us see the award first.
Yes.
Let us see the schedule.
That is Annexure 3 at page number 25.
Can we place it? Place the respective cases.
Yes. The claim of this, I am reading from paragraph 3. The claim of the sponsoring union as per its written statement is as follows. That late Tapan Gorai was appointed as permanent workman on 30/4/87, who died on 19/14 in Central Hospital, Dhanbad, and subsequently his dependent son, namely Sri Nayan Moni Gorai, had applied for dependent employment immediately after the death of his father, late Tapan Gorai, before management of BCCL as per MCWA. But after 2 years, the management, by letter dated so and so, had directed him to rectify such a defect. Subsequently, the dependent son of the deceased workman submitted the reply to the aforesaid letter by rectifying the alleged defects by letter dated so and so. After that, management forwarded the details of the dependent son of the deceased workman to Deputy Commissioner Dhanbad for verification of genuineness, and subsequently the DC Dhanbad, by letter dated 15/10/16, addressed to the project officer Basmatiya Bunjeri, confirmed the identity of the dependent son of the deceased workman. But unfortunately, the management did not provide him employment. Thereafter, the sponsoring union raised an industrial dispute before the LCC Dhanbad, but only in failure of conciliation proceedings, this reference has originated. A prayer has been made for issuance of a direction to the management for providing employment to Sri Nayan Moi Gorai, dependent son of deceased worker. On the other hand, the case of the management as per its written statement is as follows. That the deceased workman Tapan Gorai was not the son of late Madan Gorai, but he was the son of Madan Mohan Mandal, which has been accepted by the late Tapan Gorai before the vigilance department. Late Tapan Gorai is the workman. The deceased workman had obtained his employment against the land of late Madan Gorai, posing himself as son of late Madan Gorai. After that, late Tapan Gorai was
Just a moment. Late Tapan Gorai is the ex-employee.
Yes.
Okay. He claimed himself to be the son of Madan Gorai. But he was not the son of Madan Gorai, he was son-in-law.
After that, late Tapan Gorai was charged by the management under clause 26.1.1 for committing theft, fraud, dishonesty with company's business or property, and giving false information regarding one's particular for the purpose of employment. The concerned workman, late Tapan Gorai, had participated with the co-worker to defend his case, and full opportunity was given to him to defend his case. And at this end, charges leveled against Tapan Gorai was proved beyond.
Dismissal order तो नहीं हुआ ना? बात खत्म है.
He remained on the roads. That is.
But that is it. Done.
That is the case. In fact, the inquiry was also not completed. The exhibits are there. Even police verification was done in 2012. Exhibit M11. Police also says everything is in order. There is no fraud.
Finding क्या है पढ़ी? Finding तो आपके favor में, जिसका favor में वही पढ़ी. बताइए.
The findings are
from paragraph 13 at page 3.
ये तो documentary evidence सब है. Finding ultimately.
Para 34.
Page 34.
Page 34, para 3. At the outset of
Para 15.
para 15.
Para 16. Now coming to the documentary.
Para 16. Now coming to the documentary evidence of the work, when it appears that Exhibit W1 is an appointment letter of Tapan Gorai as a temporary minor loader dated 12/3/1988, and Exhibit W2 is the photocopy of verification roll of Nayan Muni Gorai. The documentary evidence of management shows that the Exhibit M1 is a letter dated 8/8/2015 addressed to RLC Central Dhanbad. Exhibit M2 is the photocopy of inquiry proceeding dated 27/9/2013. Exhibit M3 is the photocopy of appointment of inquiry officer. Exhibit M4 is the photocopy of notice of inquiry. Exhibit M5 is a letter of agent Basanti Mata Koleli allowing Tapan Gorai to resume duties after initial suspension. Exhibit M6 is a charge sheet with suspension dated 22/8/2013. Exhibit M7 is initiation of disciplinary proceeding against Tapan Gorai. So and so.
WPL number 6680 of 2023. Heard the learned counsel for the parties. This petition has been filed challenging the award dated 28/9/2022 passed by the presiding officer, Central Government Ministry of Cabinet cum Labour Code number 1 Dhanbad in reference case number 17 of 2017, whereby the learned tribunal held that non-providing of employment on compassionate ground to Sri Narayan Muni Gorai, son of late Tapan Gorai, by management of Basanti Mata Koleli of BCCL is not justified and he is entitled to employment. The learned counsel for the petitioner, while challenging the improved award, has submitted that Tapan Gorai, the father of Narayan Muni Gorai, had himself obtained employment by impersonation, inasmuch as he disclosed himself to be the son of late Madan Gorai, but he was actually son of but he was actually his son-in-law. He submits that when the very appointment of father of Narayan Muni Gorai was through impersonation, he was not entitled for any compassionate appointment. He has also submitted that appointment obtained through fraud is null and void. He has submitted that late Tapan Gorai was subjected to disciplinary proceedings, but before the matter could be concluded, he died. However, he had admitted his guilt before the Vigilance Department. FIR before the Vigilance Department. The learned counsel has also submitted that though his name was not struck off from the rolls, but the ex-employee having obtained employment through fraud has not been properly considered by the court, and therefore the improved award is perverse and calls for interference. The learned counsel, appearing on behalf of the respondent, has opposed the prayer and has submitted that every aspect of the matter has been considered, and the departmental proceeding having not been taken to a logical end, it cannot be said that it was proved that father of Shri Nayan Moni Gorai, namely late Tapan Gorai, had obtained employment through fraud. He has also submitted that the name was also not struck off. The learned counsel submits that there is no perversity in the impugn order calling for independence. Impugn award. That's it.
Otherwise, also it was Exhibit M11 also shows that the verification was done through the Office of the Deputy Commissioner's report is also exhibited.
Okay. The learned counsel has also submitted that the report of the Deputy Commissioner was exhibited before the learned court, which showed that Exhibit
M11.
Exhibit M11.
The Deputy Commissioner is giving a report saying the पुलिस अधीक्षक धनबाद से कराया गया तथा उनके विरुद्ध आरक्षी अभिलेख में कोई आपत्तिजनक अभियुक्ति अंकित नहीं।
हाँ. And the report was in favor of the father of Tapan Gorai. He has also submitted that had the disciplinary proceedings been taken to a logical end, it would have ended in favor of Tapan Gorai. यही है ना? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that pursuant to the reference, the petitioner as well as the respondent filed their respective written statement. Upon perusal of the written statement filed by the petitioner and upon hearing the counsel for the petitioner, the only objection which was taken with regard to claim of compassionate appointment of Moni Gorai was that late Tapan Gorai had obtained employment by disclosing himself, by wrongly disclosing the name of his father, rather he was the son-in-law of Madan Gorai. It is not in dispute that disciplinary proceedings, it was also disclosed by the management that disciplinary proceedings were initiated, but ultimately he died, Tapan Gorai died in the midst of the disciplinary proceedings and no order was passed and his name continued in the rolls of the petitioner. This court finds that only one witness was examined on behalf of the union, namely the claimant Nayan Moni Gorai, and number of documentary evidences were also filed. एक ही था क्या इनका exhibit W2 and certain documentary evidence were also filed. The management also examined only one witness and a number of documentary evidences were filed. The details of the exhibits have been mentioned in paragraph 8 of the impugned award. The learned court, after considering the various documents, formulated the point in paragraph 12 as follows. The learned court, after considering the materials on record, from paragraph 16, from paragraph 15 on, from paragraph 13 onwards, has recorded that no documentary evidence of the management was produced to show that the deceased workman, late Tapan Gorai, had obtained the employment by practicing fraud and willful falsification of records of the company. And the management had also not filed any document to show that the proceedings of inquiry had been concluded and the charges against late Tapan Gurai was proved. The learned court also recorded that the charges against Tapan Gurai was not proved as he was not dismissed. So at the time of his death, he was in payroll of the company of the petitioner. The findings and ultimately held that Nayan Muni Gurai was entitled for employment. The learned court further directed that if Nayan Muni Gurai had crossed the maximum limit age of employment, then the upper age limit was directed to be relaxed for his employment. And a direction was issued to give employment within a period of 1 month of publication of the award. The award was published on 28/9/20. The review order was passed on 28/9/20.
It was published on 9/11/22.
9/11?
Page 30.
The award was ultimately published on 9/11/2022. Within bracket. Having gone through the impugned award and the materials produced before the learned court and hearing the counsel for the parties, this court finds that there is no illegality or perversity in the impugned order. The impugned award calling for any interference under Article 226 of the Constitution of India. The fact remains that the management failed to prove that Tapan Gurai had obtained employment through fraud or falsification. He was admittedly the disciplinary proceedings initiated against him were not taken to a logical end, and the management failed to prove the allegation through before the learned depth. There being no merits in this petition, which is hereby dismissed. Give your appearance, please.
Orders item 5, WBC 2861 of 2012.
Petitioner.
Last date, there was direction for serving copy to the Advocate General, and
You are there? You are there?
and there was also direction to serve the copy to officer in charge Arguna PS
Yes.
for filing a complaint.
Who is representing you? WPC number 2861 of 2020 or 2012. Respondent number 2 को सर्व नहीं हुआ, कौन है respondent?
Respondent number 2 who was showing the sum of the LOT, original LOT, has sold the land to this petitioner.
Respondent number 2 could not be served.
Yes, my lord. His traceless is not found at his address, as per the office report.
Respondent number 3 कौन है?
Sir, I want to hear.
You are for the state. So you are Tell us. What is the progress of the case? FIR पे क्या हुआ?
2 minutes earlier, SSP has also filed a counter affidavit annexing all the investigation report by the order of coordinate bench of this honorable court. There is counter affidavit, but recent investigation has to be brought on record.
What is the present status? Somebody had impersonated and sold the property.
Yes.
और आप purchaser हैं?
No, I am purchaser.
आपको बेचा है?
Yes.
आप खोज के लाइए.
In a tripartite agreement, housing board has transferred the property in favor of the petitioner and a registered certificate through a registered certificate in the year 2008 itself. The fact of the case, my lord, that original allotting was allotted the property in the year 1979, and thereafter he has not came in possession upon the land. In the year 2008, when the property was transferred in favor of petitioner, then he came to.
I was in possession. The property was in my possession. I came there to get registered that land on my name. Then I found that someone has get registered, transferred this property on his name, and after transferring this land, he sold this land to Bimla Devi. Then I lodged a complaint. I submit a complaint. On that complaint, they sent a letter to Bimla Devi through Sailesh Gupta, who transferred this land.
Who is in possession now?
I am in possession.
You are in possession.
Yes, of course I am. Yes. Yeah.
Though I am in a legal possession. I am in a legal possession, and because registered certificate is in my favor.
Later, another registered sale deed has been executed between me and housing.
If there is any transfer through impersonation,
Yes.
who will decide that?
Who will decide?
Who will decide impersonation? Which court?
It is civil court.
Purely a civil dispute.
Yes.
How do we decide? FIR हो ही जाएगा तो क्या होगा?
Yes.
नहीं, इसमें ये जो रीट फाइल हुआ है, उसका एक देखा जाए.
इनका बार बाई लॉ ऑफ लिमिटेशन.
आप एक बात बताइए.
Yes.
Page 27.
Just a moment. He is in possession.
Yes, I am in possession.
ठीक है. आपको प्रॉपर्टी चाहिए?
Yes.
आप जाके सूट फाइल करिए रिकवरी ऑफ पोजीशन जो मर्जी करिए.
Registered certificate is in my favor.
तो यहाँ से ऑर्डर होगा कि आपको पोजीशन दे दें.
इनका my lord, इनका बार बाई लॉ ऑफ लिमिटेशन हो गया.
क्या हो गया? We do not know.
Article 59
You see, there is a registered sale deed in your favor.
In my favor.
And you are dispossessed from the property.
No, I am not dispossessed. I am on legal possession. I am.
So how
He
has
is also not in possession, my lord.
No, I
Who
am
is in possession?
No, there
I have constructed 2 rooms.
Just
I
a
have,
moment.
Yes, my lord.
Who is living on the property?
There is no any as per
I have constructed 2 rooms and boring.
एक चीज एक.
Yes. Only there will be
नहीं,
bail.
आप हमको एक बात
Yes.
बताइए. If there is an impersonation in execution of a deed, which is a registered document, right? Then under such circumstances, whosoever is not in possession will have a cause of action.
But my lord, I
want to
approach before this honorable court only against the letter written by the housing board, only for passing of that letter. So
and
I
we have that letter.
Only for passing of that order.
Page 27.
But ultimately that boils down to the fact whether there was impersonation or not.
They accepted that it is impersonation. Everyone has accepted that it is impersonation.
Accepted से थोड़ी होगा कुछ. Accept करने से क्या होगा? Impersonation था कि नहीं था ये बताइए.
Yes. Subsequently, it has to come within the knowledge of all the parties.
आपने impersonation से खरीदा है.
Yes.
You are a beneficiary of a document.
But
you are a beneficiary of a document in which one person was an impersonator.
My lord, I am permitted to read one sentence in page number 15.
आपको एक बात बताइए.
Yes.
जिस तरह का dispute हम लोग इस रीट में डिसाइड करने का कोशिश कर रहे हैं.
It cannot be
रीट
decided.
में होगा?
No, my lord, no.
तो आप जाइए अपना सूट फाइल करिए.
But this letter has to be quashed.
No, why it should be quashed?
Because it is
You
against
just-
me. It is against me.
you.
As because the housing board has transferred the property in my favor through registered sale deed.
You see,
and subsequently
on impersonation.
this is a consequential letter.
Yes.
Ultimately, whatever is decided with regard to impersonation or transfer or whatever, this letter will be governed by that, isn't it?
Yes.
And housing board will also be a party in that proceeding.
Yes.
इतना सिंपल सा चीज है, कितना कंप्लीट में 2012 से चल रहा है यहाँ. Impersonation यहाँ डिसाइड करें.
Yeah, so this is not my prayer, my lord. This is not my prayer that this will be decided by this honorable court. My prayer is only for the effect that this letter ought to be quashed by this honorable court, as because the registered sale deed, though there was in but there is a registered
आपको
sale
कोई
deed.
आइडिया है अगर कोई impersonation से कोई डॉक्यूमेंट एग्जीक्यूट होता है, it is rank null and void.
Yes,
null and void, but this
उसके लिए तो कोई डिक्लेरेशन का भी जरूरत नहीं है. If it is an admitted fact that
this document has got legal value as because it is a part by Article 59 of Limitation Act.
कैसे?
There 3
What
years
should-
only.
should-
The registered
इतना
sale
आसान
deed has
नहीं
to
है
be set
limitation
aside.
act, इतना
Registered sale deed has to be set aside within the 3 years from the date of knowledge, and all the parties has knowledge that there is a sale deed.
आपको भी
In
तो
the year
knowledge है.
2008 itself, there is later, my lord, and also the investigation officer has also pointed out in the counter
देखिए
affidavit
यहाँ पे
that
तो लॉ का क्लास नहीं चल रहा है, ठीक है?
Let us say,
We will not say anything more.
petitioner has, ये जो petitioner है, ये एक नहीं कई प्रॉपर्टी में ऐसा कर चुके हैं. हम ये कहना नहीं चाहते थे यहाँ पे.
then bring on record. Who will?
दूसरी चीज, ये बात जो इम्पर्सोनेशन का हो रहा है, जैसे ही इन्होंने ये ट्रिपेटाइट एग्रीमेंट जो बोल रहे हैं, ट्रिपेटाइट एग्रीमेंट किया है, और जब ये आए हैं, ये रिस्पोंडेंट नंबर 4 यहाँ पे आए हैं और आकर के देखा है कि ऐसी बात हुई है, इन्होंने उसी टाइम ऑब्जेक्शन किया है और उसी ऑब्जेक्शन के आधार पे इसको कैंसिल कर दिया.
ये जो एनेक्शल इम्प्यून है, एनेक्शल 4, okay? This is issued by the housing board.
Yes.
And it is stated therein that failure that they have been asked to vacate.
Yes, they asked to cancel.
नहीं, ये बोल रहे हैं कि अन्यथा निबंधन डीड की रद्दगी हेतु सक्षम न्यायालय में कानूनी कार्रवाई की जाएगी. बट
या तो आप नहीं, पहले बोले कि या तो इसको आप सबमिट कर दीजिए ऑफिस में, नहीं तो हम इसको कैंसिल कराएंगे. ये कहानी इसमें लिखा है. तो उन्होंने सबमिट किया नहीं. अब इनको इसको कैंसिलेशन के लिए एक पिटीशन एप्लीकेशन फाइल करना चाहिए था सिविल को, जो अब तक नहीं.
कौन कैंसिल? इस लेटर का कैंसिलेशन?
ये नहीं, इस जो ट्रिपेटाइट एग्रीमेंट ये बोल रहे हैं, एग्रीमेंट को कैंसिल करने के लिए एक एप्लीकेशन फाइल करने के लिए इसमें लिखा गया है कि हम फाइल करेंगे जिसका खर्च आपको वहन करना होगा, जो इम्पर्सोनेट किया है.
तो ये तो हाउसिंग बोर्ड चिट्ठी लिख रहा है
जी.
अब जाके जो मर्जी करिए. You are a party to a document, and you don't want to get it cancelled.
We want to get it cancelled, my lord.
How will you get it cancelled?
No, my lord, what had happened that he impersonated to be the son of this respondent number 5, and submitting his forged death certificate and a genealogical table, my lord, he got that deed executed. Now, as soon as the respondent number 5 approached the housing board, we cancelled that, we transferred that back to the
And the actual owner is now in possession of the property.
My lord, he is in possession. The original allotee, Saroj Kumar, is in possession.
You want possession? What do you want?
Yes, my lord, I want possession.
जाइए सिविल कोर्ट में possession लिखिए.
And his respondent number 2 is not accepted. Who is the person who impersonated?
Impersonate की तो वो कहाँ से appear होगा? How do you know his identity?
It's not appearing. They have made him a party over here.
Second आप इसका order
Yes,
करेंगे,
ma'am.
थोड़ा पढ़ order.
Yes.
ठीक है?
But before that, my lord, I want to point out that one line, only one sentence at page number 15 of my writ application. In this letter, the Bhu Sampada Padadhikari J.J. Tirki has wrote letter that person Shailesh Kumar Gupta. Third line, उपयोग विषय के आवेदन में आपके अनुरोध पर उप भूखंड को श्रीमती विमला देवी के द्वारा त्रिपक्षीय अनुमति दी जाती है. That means I have not approached. He has approached to the housing board and आपके अनुरोध पर this was
आपके मतलब कौन किसके?
Salish Kumar
impersonation. Yes.
And subsequently
And you are actual Salish
Yes,
Kumar.
right. No. Actual Saroj Kumar Eloti. Actual Eloti is Saroj Kumar.
Salish Kumar Gupta has stated before the housing board that Saroj Kumar Gupta has died and I am a son. Kindly substitute me. And thereafter substitution was done. And thereafter this proceeding was initiated. Deed of tripartite.
So you admit?
Yes.
It's a very serious statement that you admit.
What we know?
That you admit that there was impersonation.
No. Subsequently, it has to come in the knowledge of the petitioner.
No,
Why
maybe that at that point of time you were not aware.
Not aware.
But is it an admitted fact now
Now,
that he was
yes.
an impersonator?
Yes, my lord. As because he is filing an affidavit showing that he is alive, he is present in the court also.
तो वो तो डॉक्यूमेंट जो भी है आपका null and void हो गया.
नल एंड वॉइड नहीं होगा. एक्चुअली बार लॉ ऑफ लिमिटेशन इनका हो गया. ये बार बोल रहे हैं, इनको नॉलेज है 2008 से ही कि ये सेल्डेड हो चुका है और ये 3 इयर्स के अंदर ये नॉलेज डेट ऑफ नॉलेज से सेल्डेड को नहीं है.
नहीं जैसे ही
तो वैलिड हो जाएगा वो.
वैलिड तो एज पर द आई ऑफ लॉ वो तो प्रूव करना होगा ट्रायल कोर्ट में.
ठीक है. सेकंड आप देखिए इस तरह का स्टेटमेंट मत कोर्ट में बोला करिए.
नहीं
एडमिटेड फैक्ट.
एडमिटेड फैक्ट ये फ्रॉम द डॉक्यूमेंट अवेलेबल ऑन रिकॉर्ड. It is my submission, fairly submit. I am fairly submitting to this court.
आप आएंगे सेकंड आप. ठीक है. तो पूछिए क्या किया है एफआईआर का, लेकिन ये सूट का केस है, रिट नहीं डिसाइड करेंगे. और जो पार्टी एग्रीड होगा वो सूट फाइल करेगा.
Yes, my lord.
किसी को उस सेल्डीड से परेशानी है वो करेगा. जिसको पोजेशन चाहिए, आप तो डिस्पोजेस्ड है, आपके पास तो कोई ऑप्शन ही नहीं है.
पोजीशन एज पर माय ये है कि लीगल पोजीशन मेरे पास है. लीगल पोजीशन,
कंस्ट्रक्टिव पोजीशन, लीगल पोजीशन,
लीगल
सिंबॉलिक पोजीशन, क्या पोजीशन?
अब ये डिस्प्यूट कर रहे हैं कि नहीं वहाँ प्रॉपर्टी पे सिर्फ एक वेल है, कुआं जो खुदा जो बहुत पहले
आप
से
हैं
है.
मिस्टर प्रभाष कुमार इसमें क्या? अच्छा ठीक है. हम
Yes,
इसको
my lord, yes.
लिखाएंगे हम सेकंड.
Yes,
में.
After the judgment I have given to the
अच्छा. कौन सा वाला 74 वाला?
74. Para 12.
दे देंगे. फॉर आपने फॉरवर्ड किया है.
नहीं
हार्ड कॉपी फाइल में लगा.
फोटो कॉपी
Obliged.
For this item 6, WPC 2880 of 2018.
ठीक है.
In the last order, you were directed to file a supplementary showing the service made by us on Dasti Saman. Now we have filed a supplementary also, saying that the respondent number 19 Mati, living in Mackay, and we had gone there, my lord, but she personally refused and denied to take the notice. As will be seen by the endorsement made in the notice, we have annexed. In
क्या
presence
लिखा
of
है
villagers,
इसमें? किसको भेजना था नोटिस?
नोटिस जाना था ज्योत्सना देवी को.
ज्योत्सना देवी को. ज्योत्सना देवी ने नोटिस लेने से इनकार किया. ओके, आगे शादी करके भी वहाँ नहीं.
और ये पहले हम लोग इधर तालझारी गए जहाँ ये इनका ससुराल है ज्योत्सना देवी का. तो ससुराल में इनके ससुर बोले और वही लिख के दिए हैं कि वो मेरा बेटा जो है वो अपने ससुराल में रहता है, मतलब वो ज्योत्सना देवी मायके में रहती है. देन मिलॉर्ड फिर उसके मायके वहाँ पर गए और वहाँ पर जाके ग्रामीणों के समक्ष शी रिफ्यूज टू एक्सेप्ट द नोटिस.
ये नोटिस कौन से ऑर्डर से इशू हुआ? स्टेट है यहाँ
21/10 का उनका ऑर्डर. और सब अपील
कहाँ का एड्रेस है ये?
अभी है तुलसी टावर।
हाँ,
तुलसी टावर देव।
पुलिस स्टेशन के थ्रू कभी नोटिस गया है?
पुलिस स्टेशन
उन्हीं के थ्रू भेजेंगे, पुलिस स्टेशन के थ्रू नोटिस भेजेंगे।
लीगल यस
आप हैं लीगल यस?
Other restaurant, they are making false statement before the court, my lord. The fact that she is living in Tulsi Town. How is married?
कहाँ रह रहे हैं बताइए?
She is residing in Katahara, Tuna. That is in the order set part by your lordship in other case, my lord. Which has been annexed in the IA, my lord. IA number 9468 of 2011 by the petitioner himself.
ज्योत्सना देवी के ससुर का स्टेटमेंट हम लोग उसमें उनके हाथ का ही लिखा हुआ लगा है, मनोज यादव सही की कि वो अपने मायके में रहती हैं, मेरा बेटा भी वहीं पर रहता है अपने ससुराल।
Page 11.
आइए नंबर बताइए कौन सा आइए?
आइए नंबर 8861 of 25. With regard to that,
वो हम लोग प्रेस नहीं कर that we are not pressing.
No, इसमें भी रिकॉर्ड।
कौन सा आइए नंबर?
8861 is not present.
आइए नंबर 8861
of
2024. Also for the petitioner submits that he does not want to press the interlocutor.
He is not pressing because he was suffering from suppression of fact.
ठीक है, तो उसको हम लाएंगे, जो
Accordingly,
सप्रेशन हुआ है उसको ला देंगे ना भाई।
8861 is dismissed as not pressed. The petition was filed seeking amendment of the petition. ठीक है, और दूसरा आइए बताइए कौन सा है?
तो दूसरा हम लोग फॉर रेस्ट्रेनिंग लॉर्ड।
नहीं, आपका सब्स्टिट्यूशन वाला पैसे नोटिस का कहानी नहीं खत्म होगा तो कुछ नहीं। आप बताइए एड्रेस उनका बताइएगा। 9468 में है, बताइए 9468 में।
And it's a 2 at page 11.
Page 11. Yoshna Devi.
Yoshna Devi. They have
Roman 8 is the right address?
yes, right address. And
आप कौन है? You are one of these.
Mother, we are appearing on behalf of the mother and brothers of this lady.
This lady?
And they have mentioned the name of this petitioner also wrong. Josna Devi. They have mentioned Josna Devi.
It should be Yoshna Devi.
Josna Devi.
The learned counsel for the parties are present. ऊपर लिखिएगा, ठीक है? The counsel for the private respondent has submitted that the name of the legal heir, one of the legal heir of deceased respondent number 1, which is respondent number 1 within bracket Roman 9, is Yosna Devi, Y-O-S-N-A Devi, D-E-V-I, whose correct description with her husband's name and her residential address has been mentioned in the writ petition being WPC number 7316 of 2011. And the name has been substituted as Josna Devi, J-O-S-N-A Devi, which is not correct. आप करेक्ट करेंगे नाम उनका? Counsel for the petitioner, at this counsel for the petitioner undertakes to, is permitted to seeks permission to correct the spelling of legal year of respondent number 1, Roman 9.
As Yoshna Devi.
As Yoshna Devi instead of Josna Devi.
No.
He may do so in writing during the course of the day. The counsel for the private respondent has submitted that if the notice is sent to Yosna Devi at the address which has been mentioned in WPC number 7316 of 2011, where she is one of the petitioners, the notice will be served. Issue notice to Yosna Devi, wife of Pradeep Yadav and daughter of
late Kinkar
Yadav, resident of Taljhari, Kathatona, POPS Taljhari, district Dumka.
तालजारी तो ये कह रहे हैं कि हम लोग तो सर्व करने गए
Through the concerned police station, for which requisites be filed by the petitioner by Monday. Okay? The counsel for the state is directed to seek instruction from the officer in charge of the concerned police station and file affidavit of service. The affidavit of service of notice should also enclose a copy of the Aadhaar card. Aadhaar card लेके file करेंगे. A copy of the Aadhaar card of Yosna Devi. Post this case on 16th December. Affidavit of service should be filed by 12:46.